The last thing that I want to talk about is this whole thing about force majeure clauses and frustration and terminating your agreements based on this coronavirus. The one thing I'll say about that is, let's talk about that. So, people are losing their jobs. Their mortgages are getting pulled left, right, center. The question is, what does the law say about the parties' rights in these circumstances? Are there any general principles that apply? So number one, the coronavirus and the effect that it's having on contracts is actually unprecedented. Now, it's not every day that we get to say that in law, but in modern history, so that's the last 100 years, we have no cases that can help or assist us in determining whether these contracts apply or how they're modified during this situation. So we have to go back to our first or kind of initial principles and our contract law 101, so to speak. So we have to go back to the agreement. What does the contract say? What does the agreement say? Is there an entire agreement clause? Is time of the essence? So basically what that means is the time frames that are in the contract are going to continue to govern this contract. There's no law out there, I'm sorry to say, that says your obligations are suspended in a private contract. And nothing in the government suspension of time limits affects private contracts. So it's a private contract that you have entered into with another party. Everything governing that contract is within that agreement. And you will still be expected to honor the terms of those agreements. Force majeure clauses are actually contracts that are found in leases and construction contracts. You'll rarely see them in real estate transactions. If there is one, it would require interpretation, and still it would need to make kind of express mention of a pandemic, and so you would be hard pressed to be able to rely on anything like that. Frustration of contracts is another kind of academic term that's thrown around. It's a basis for avoiding a contract or terminating a contract, for lack of a better term. And it is applied when a contract without the fault of either party cannot be performed due to an unforeseen event, and this event renders it impossible to perform the contract. Now, you need clean hands, and what that means is that, for example, you can't already be in default. One guy called me and said, "Hey man, this thing's going on. I want to get out of this agreement. By the way, I only paid $10,000 deposit. There was another $10,000 deposit due last week, and I just didn't pay it." Well, now, not only may you not be able to get out of the contract because of the pandemic, but you've already been you're in default because you're in breach of that agreement before you're even able to come to court to talk about the coronavirus. So, and the event must not have been reasonably foreseeable. And the event must render it impossible to perform the contract. So delays, loss of mortgage commitments, drops in your investment portfolios or your investments will not get you very far in court with these arguments. Unanticipated costs or economic loss or delay in performance are not considered radically different, is what the courts say, than what the parties originally intended. And as a result, frustration of the contract will not apply. So, in conclusion, you still have an obligation to act reasonably and fairly in performing the agreement. Once you sign that agreement, you must try to reasonably and fairly perform that agreement. And the lawyers out there, please be careful of saying things like, okay, well, this agreement is now terminated because of the coronavirus, because this could actually trigger what's called an anticipatory breach, and you might find yourself on the wrong side of a lawsuit because you indicated to the other side that your party does not want to complete this agreement. There's no precedent out there. There's nothing out there that can definitively say that a pandemic will get you out of a deal or entitle you to any accommodations. So what does that mean? That means what you're entitled to and what people agree on are two different things. What you need to do in this situation is keep open lines of communication. Hopefully all parties are reasonable and they can come to some type of mutual agreement or mutual release if that situation or that offer is on the table. Do not listen to anyone who's telling you that, oh, for sure you can get out of your deal, 100% guaranteed you can get out of your deal because of this coronavirus. That is not good legal advice. That is kind of the last thing that we actually tell our clients in this situation. So in this case, there's no kind of one size fits all type of advice I can give you. It's going to be on a case by case situation. So if you do have specific questions, please reach out to me via telephone or email. We can set up a video conference and we can discuss your particular deal and how we can kind of salvage it or get it to a point where it's a mutually beneficial agreement for everybody.